Hello, guys. Well, my name is Kalu.
My name is Paul Jadafor,
Rachel Lawrence.
Danny Connolly.
and we're going to be presenting a comparison of the legal systems of Nigeria and the U.S. So overall, Nigeria was a colony similar to America's. In the initiation of their legal system, they had traditionally customary laws that were varied between tribes and regions in Nigeria, as well as Sharia law, which is a religious law of the country. That's used mostly in the north, but overall they use mainly the same English common law system as the U.S. does, and they use the same process of presenting evidence in court, such as the U.S.
Okay, so a little more about the common law system. Common law is a very common law. It's English, so a lot of the English colonies, like ourselves, have a common law system. It's also common in French colonies and Belgian colonies. Basically, what the main things about it is it helps form your judicial system, your three branches of government, as well as your constitution. So their most recent constitution was in 1999, and it's a common law system version. It also helps form the way they legislate, as well as their court system.
Customary law originally originated from small villages and small communities. They would have customs that were accepted as legal requirements or obligated rules of conduct in regards to practices and beliefs of the community itself. Now, as there are many tribes in Nigeria, the customary laws throughout Nigeria vary greatly, and as well as the types of customs that are accepted as law will vary as you go around country. Customary law generally, custom is a traditional and widely accepted way of behaving or doing something in a specific society. So as those societies change, those laws as well change. Customary law varies in three major ways. It varies geographically, among ethnic groups, and among religious groups. In Nigeria, there are about 36 states. So each state has its own constitution, as does the U.S. There are three major ethnic groups among those states, though. They are the Igbo, Yoruba, and Hausa Fulani. And within those ethnic groups, they also vary in religion as well. Like the Igbos traditionally were descendants of the Jewish lineage, so they practice Christianity and that type of religion, while the Yoruba is kind of a mix, and House of Fulani is strictly and predominantly Muslim. Every customary law was once a custom, but not every custom was made into a customary law. As times changed, customs began to change. Most customs deal with the issue of life, like people's lives. So, for example, marriage laws. In most tribes and communities, before you can get married, you must have a betrothal, which is pretty much a proposal, and upon that, you must pay a dowry to the family of the female. So that's just one example of customary laws. And if the dowry is not paid, the family can sue the man for marrying their daughter without their consent, just because of how their tradition is that you come to the parents when you propose to the woman and ask their permission and ask for their blessing as well. Customary laws were traditionally enforced by the leaders of the community. They would gather the elders of the panel, and if somebody had broken said law, they would decide that way through the leaders whether or not it would what the punishment would be and how they would carry out that punishment. Customary law has about 4 or 5 fundamental features. It must be existing in the time that the claims are being made. So when somebody makes a claim to a customary law in court, the custom must be currently accepted as a custom within their specific society. Meaning that if in one community there is a custom that's existing right now, and over time that custom changes, you cannot make that same customary claim in a different time, where they're not using the custom. The law itself is generally flexible. That means that when they give specific wordings, because they are unwritten, the law may be flexible to a different application, a different scenario than it was originally intended for, because it's unwritten, and they use a form of precedent, but the precedent will change. It must be universal to a given community. That means that within the different communities, different customs are accepted. So if you are in the northern states and you're operating under Sharia law, that does not apply to other states generally. But if you are a member of another state and you go into the state where Sharia law is being used, you are still subject to those laws. And it must enjoy acceptability as a custom. So people must accept it, and they must be consciously aware that it is a custom and it's a law that is being enforced. That's the overview of customary law.
We're moving on to the history of the Islamic law, Sharia law. We learned that the most popular religion in the northern part of Nigeria is Islam, and Sharia law and Islamic law comes literally strictly from the Quran, the Prophet Muhammad, unanimous agreements from learned Islamic scholars. So all of those scriptures and wordings make up the Islamic law. Like Paul previously said, one difference between customary law and Sharia law is that Sharia law is actually written out. So it's actually written out. So there still might be challenges, but it's written out and it's ranked.
They hold, and the thing with Sharia law is that they hold people directly accountable to the exact law itself. There is no leeway, there's no lenience, there's no interpretation of the judge. They strictly go to the rulings, and if you were abiding by the law, you're abiding by the law, and if you're not, you're not. There's no in between.
So one example of that would be, say, like intoxication. In the Quran, it says that drink, and so if someone was caught out, maybe having a glass of wine or some alcohol, they would be subject to going to jail for that, even if it is a criminal offense or smaller offense. I feel like that's something that's a little bit interesting, and it may be different based at we're in America, but it's their custom there, and they follow that. Also, in the Islamic community, the Holy Quran is like the supreme law, and it has final authority over all other customs in the northern part of Nigeria. So I believe it's 11 states that make up the northern part, and they all follow Sharia law. Also, moving on, Nigeria and America has some similarities. One similarity would be that they both follow the separation of powers. In the Islamic legal system, the executive branch is called the IM, Their judicial power is called the KD, and the legislative power is called the Itama. Also, moving on to like their trial process. Under the Islamic law, monarchs, chiefs, and elders of the community, they are involved in establishing guilt and criminal and civil different processes. Sometimes the confessions, one fault of it is that sometimes the confessions may be coerced. Oftentimes we hear that um, people were threatened into confessing. So that was one problem that we researched and that we figured out. Also, based off our research, we found out that the process of finding someone guilty is often cheap, quick, convenient, and majority of the time it is convincing, but the burden of proof is not always that high. It's often based upon like strictly suspicion. Um,
This is due to the judges throughout Nigeria possessing an extreme amount of discretion. There is very rarely any jury trials throughout the country of Nigeria. Most trials are bench trials, and it's depending on one judge until you get to the Court of Appeal to make the decision on the case. Um, like he said, a lot of the decisions were made by the elders and leaders of the community, and that's due to the authoritative nature of Nigeria. They are very big on community and the leaders of the community being the leaders and making the decisions for the community. So it comes from the power of the head of the family because they consider if you ever heard the term "it takes a village to raise a child," they consider the village to be a family, and the heads of the family are the ones that are going to make the judgments, are going to make the decisions about the laws for the family. Like your father sets the rules of the household, the leader of the community sets the rules for the community.
so moving on, we briefly researched the different crimes. What happens if you are convicted of that? We found out that the hudud are like more serious crimes, and they have mandatory sentences or that. A couple examples of that would be if like rebellion, you could be sentenced to death strictly off of having a rebellion against the government. For adultery, you could be stoned to death. From drinking alcohol, you could be sentenced to flogging. Flogging is being hit with a whip over and over again. I believe the maximum times you can get hit is 12 times. For drinking alcohol, like we previously talked about, um, yeah, and then for stealing, it would be loss of limbs. The punishment for less serious offenses is just based off the judge's discretion. Discretion, yeah, I can talk. Um, that can range from fines to seizure of property to idle threats, but all the way up to being exiled or sentenced to death. So,
Okay, so moving on to types of courts. In Nigeria, well, first starting out in the US. So in the US, um, we have federal courts, state courts, and some smaller, more inferior courts. Nigeria is similar. So federal courts in Nigeria include the Supreme Court of Nigeria, the Court of Appeals, the Federal High Court, the Customary Courts of Appeal, and the Sharia Court of Appeal of the Federal Capital Territory. Similar to the US, the Supreme Court is the highest court, and all decisions from the Supreme Court are to be followed by all the lower courts. It's also the final court in respect of state laws. And in terms of state courts, these include the High Court of the State, Sharia Court of Appeal of the state, and the Customary Court of Appeal of state. State high courts are the most important courts in each state in terms of administrative responsibility. The high courts of each state are established by the Constitution, and then each state has the ability to establish a Sharia Court of Appeal or a Customary Court of Appeal, or both, as they see fit. And then the House of Assembly may also abolish those courts which they have established if they no longer feel the need for it. The inferior courts are established by legislation of state assemblies through the powers granted to them by the Constitution. Similar to the United States, the Constitution grants certain judicial powers to create courts within the U.S. In Nigeria, these include magistrate courts, district courts, area or Sharia courts, and customary courts. These inferior courts reside under the supervisory and appellate jurisdiction exercised by the high courts, as well as other specialized courts. In terms of jurisdiction, a particular court has power to entertain a case only within a specified geographic area, so from state to state, similar to the U.S., where we also have state-by-state jurisdiction, whereas one state does not have jurisdiction over the case that has resided in another state.
And along with jurisdiction, in regards to different types of law, such as the customary law, as you climb the hierarchy of courts, they pay less attention to customary and religious laws, and they pay more attention to the common law system and precedent of other Supreme Court decisions and other Court of Appeal decisions, and some of the higher courts, just because of the not inconsistency, but the unwritten part of customary law. They cannot, and how customary law varies among the states, they're not always going to accept it as a valid accusation or as a valid form of law within the higher courts.
Okay. Next is the lawyer qualifications. So in order to become a lawyer in Nigeria, you have to have some form of post-secondary education before law school. Then you have to attend the Nigerian law school. The Nigerian law school is available in 5 cities in Nigeria, including the capital. No, cities. Okay. In order to get in, you have to do that. You don't have to have an LSAT like you do here. There's no type of like test to get into law school besides, I believe, your grades, like GPA, and some form of maybe essay to get into Nigerian law school. But there's no test that we have here. There is a bar association and there is a bar exam in Nigeria. It's a countrywide thing. I don't believe it goes from state to state. It's just Nigerian Bar Association as a whole. The next thing is the Supreme Court. So in Nigeria, the Supreme Court consists of 16 justices. Each case, though, only has 5 justices per case. So you don't have you have an uneven number. So there's always a different number of majority. Yeah. You have to be qualified to practice for over 10 years in order to be in a Nigerian Supreme Court, as in like private practice or any kind of firm or even through the government. In the United States and in Nigeria, you both get lifetime appointments to the Supreme Court. So once you're there, you're stuck there. And also in Nigeria, there are only one type of appointment, and it's appointment by you get selected by a national committee, then you get approved by the legislature, and then the president signs off, or prime minister signs off on your appointment. And then in the United States, we have the 5 different types of selection, unlike they do in Nigeria.
Also, similar to the U.S. and Nigeria, if you are appointed to the Supreme Court, there's always the option of resignation if you no longer want to take the job, as well as if for misconduct, you can be impeached from your position if you are not following proper judicial conduct. Okay, so the legal process in criminal cases for the U.S., as we've learned about through our class, starts with a crime that is committed and then reported, which incites investigation, leads to an arrest. The defendant faces an initial appearance. Judging between if the defendant has a grand jury trial or preliminary hearing, one of those will happen. The preliminary hearing, if no grand jury, will occur and then lead to bail or detention. From there, if you do have a grand jury trial and you're indicted, you face arraignment, and then comes the trial process, which, if you're found guilty, leads to your sentencing and possible appeal. So significantly in Nigerian legal system, you, of course, start out with a crime that's committed. The reporting process goes through what is called the charge room. In the charge room, an officer hears the complaint of a crime. This officer may dismiss any complaint on the ground that is false, trivial, vexatious, frivolous, or civil, but they must record all complaints. So if they dismiss it, they have still record of the complaint that was made. So after that initial report comes if the case is brought to the next level, it is brought to the crime branch. And within the crime branch are IPOs, which stands for Investigating Police Officer, who receives the case referred to them and investigates the complaint. Significantly in the Nigerian legal system within the crime branch, complaints against juvenile delinquents or women are generally assigned to female officers who are known as WIPOs. So there's that. And then after the investigation is complete, the IPO puts up a comprehensive report and recommendation to the superior officer of their position. So if they have investigated and feel like there's not a lot of grounds to pursue the charge, they will recommend to drop the charge to their superior officer, or if they've investigated and they feel like there is a lot of cause and evidence for the charge, they'll recommend that. And that's known as the review of the superior. Certain cases are referred to the Attorney General, and the superior officer may refuse the case if there's no credible witnesses or enough evidence in that they feel.
Sorry, I was just gonna speak on the reason why the police officers have the option to release a case or like put it aside because they don't feel there's enough evidence is because of the tendency to people around the community sometimes hold grudges against each other, and they will bring false accusations a lot. And so it's up to the police officers themselves to also determine whether or not these accusations are claims that they should follow up on, or if they're false claims that should be dismissed. They still keep records of all the claims just to see if there's a pattern with a certain person reporting, or if there's a pattern with an actual pattern with somebody continuously committing these crimes.
Mm-hmm. And then if the complaint leads to a charge and then to an arrest, police may arrest. Police discretion to arrest comes with or without an actual warrant. They can arrest anyone who commits an offense in police presence. So reasonable suspicion, reasonable grounds, or who that police officer as suspects upon reasonable grounds of having committed an offense. So that's similar as well to the U.S. legal system. Something significant about the Nigerian legal system is that private persons may arrest another without warrant and hand them over to police. So that gives individual persons the kind of responsibility to do that.
It's kind of like how we have like citizens arrest.
Mm-hmm.
It's literally.
Mm-hmm. And then from the rest comes the appearance in court, the first appearance, where they state their plea of guilty, not guilty, and the trial. As we stated before, jury trials are not nearly as common as we see in the U.S., and many trials are bench trials. Verdict comes into play with the sentencing. For sentencing, the use of allocution comes into play, and allocution is a process in which the defendant speaks to evidence of their own past conduct, such as in their employment, their family life, personal life, and kind of their life circumstances, and that is to help the court arrive at an adequate, individualized, and just sentence that speaks to the individual and the circumstances of the crime. And possible sentences may include imprisonment, probation, and the death penalty, obviously based on the severity of the crime. All of these are shared in the U.S., but different from the U.S. However, as Kalu spoke about, in terms of Sharia law and Islamic law, flogging, stoning, some capital punishments that are that we in the U.S. might see as extreme, can be used in those northern parts of the country where Sharia law is practiced. Also, something significant is criminal defendants may be sentenced to pay damages, fines, and compensation, whereas in the U.S., criminal conviction results in jail or prison time or parole or probation, and it's in civil court in which defendants found liable may pay a settlement or fee or compensation of damages. Also in Nigeria, the Criminal Procedure Act statute provides legal aid for persons accused of capital offense who are not otherwise represented. So that's similar to the U.S., how we grant the right to legal counsel for indigent defendants. Persons accused of capital offense who are not otherwise represented are given legal aid in Nigeria, as well as people facing the death penalty and on appeals as well. All the way up to the Supreme Court. Statutes provide legal assistance for those indigent defendants who can't receive legal assistance elsewhere, other than through the state. And so throughout the criminal process, legal aid is available, and like I said, all the way up to the Supreme Court.
The legal process in civil cases, starting with Nigeria. One thing that I did not know until doing this research was that the earliest form of action was actually private vengeance. Oftentimes, well, not oftentimes, but if something happened where someone either stolen some money or just a dispute happened, the bigger, stronger the person with the arms will take matters into their own hands to either retrieve their stuff and oftentimes it ended with death, a lot of deaths. So the government had to step in to solve this problem, and that led to them adapting the rule of how they do things now. So they start with so an injury occurs or something, a situation happens. The first thing that happens is a commencement of civil action. So that's basically it's three different ways to go about our procedure. So the first and the one that happens most often is a writ of summons. A writ of summons is an official order for someone to appear in court when they've been accused of like just breaking a law or committing an offense against someone or in a party. Something that happens sometimes, usually through like marital divorces or maybe elections, is like petitions. People would sign petitions to bring people to court. They had enough signatures from the community. They had enough signatures from the community. Um, the other party would be liable to show up in court. The last commencement of civil action will be originating summons. An originating summons is a document which formally begins a legal case where usually both parties agree with like the facts of the case, but they need like a judge to step in to decide how to interpret the law. So that's one thing I thought was interesting. The next part is usually the procedures. That's basically when they would reach out to different lawyers and attorneys to see if they could represent them if they want to go to court. Sometimes just like in the USA, they solve problems out of court if they don't have funds or if they feel like it's too much hassle or it's just not enough, not just not worth it. They will settle it out of court. Um, and then next, after they, if you decide to go to court, after you got your attorneys, it would be the trial. The counsel decides the appropriate form of action in the complaint, and then he files that complaint with the clerk of the court and pays the necessary fees as assessed by the court. Um, then, after the fees and all that is handled, the judge usually hears the case. Oftentimes, it's always a bench trial. Based off of my research, it was less than 5% if there was ever um, a jury trial for a civil case. I believe also for criminal cases, there's hardly ever jury trials as well. And then, like I said, the judge um, interprets the law and makes his verdict off of it. For the United States, as we know, for a criminal case, usually an injury occurs, and the person that's usually injured files a grievance. After that, they file a claim, and then they decide if it's worth going to court or reaching out to a third party or just individually solving the case, if it's worth going to court or not.
The appeal process in Nigeria is very similar to the appeal process in the U.S. As the U.S., you have a case selection between whether it's a federal court of appeals, a circuit courts, or the Supreme Court. They set an agenda, schedule the hearing. Then they begin info gathering, previous case precedent, facts of the case. Then they create a legal brief, pre-trial, and then oral arguments and the decision. And then they decide how the court wants to tell the other court the judgment has been reversed or is upheld. In Nigeria, it's very similar, other than you file a competent notice of appeal with the court that the original decision was made. You file the appeal there and send it to either the Court of Appeal or the Supreme Court to get your appeal heard. The federal court in Nigeria uses a three-judge panel, similar to the U.S. And that's pretty much the appeal process. It's almost exactly the same.
So overall, the comparison between the United States and the Nigerian legal systems, they're very similar. Some of the main comparisons we made were that they both have the common law system. They both have state-by-state jurisdiction within the courts. Supreme Court and the Constitution have authoritative ruling, as well as the separation of powers within the courts. Some prominent differences were that in Nigeria, the use of additional law forms, including customary and religious law, whereas in the United States we have the separation between church and state. Also, in the US, we have an adversarial system. The Nigerian legal system is less adversarial in the sense that they have
in the sense that they present the evidence to the judge and the judge makes the decision based on the evidence and the claims of the defendant themselves. It's less back and forth between lawyers and witnesses, and more of a presentation of the case in a very formal manner, and the judgment by the judge strictly based on the facts and how they presented the case.
Mm-hmm. The other prominent difference we discussed was the Supreme Court, the actual judges that sit on the Supreme Court. So in the US, as we know, we have 9 Supreme Court justices who all work together to decide each case they work on, whereas in Nigeria, as we discussed, have 16 Supreme Court justices and 5 sit on each case at one time. Yeah. Any final comments?
I would just like to thank you for taking the time to watch our presentation.
Thank you.